This was standard procedure handed down by all the big banks. All these assignments of mortgage are fake. It's a felony, man. And that actually leads us into the realm of the truly earth-shattering secret that this is all designed to hide. You know, being a debate person, a master debater, so to speak, it's kind of a natural progression to become an attorney. I got a scholarship to law school, graduated, and almost immediately started my own firm. Then, I mean, the foreclosure thing hit, you know, and
What year was this?
That was about the end of 2009. Well, it was 2009, really, when we started having so many, you know, foreclosures, and basically it was the Great Recession, you know. So as a result of that, or maybe as the next step in the banker's plan, we had a recession and we had lots of homes going into foreclosure. So as a guy who has a little mom and pop law firm there in a strip mall, you know, it just seems natural, I guess, that I would start to get some foreclosure cases to defend. And, you know, a foreclosure is basically a breach of contract case where, you know, you made a contract, you signed a contract that says, in exchange for being able to live in this house, I'm going to pay X number of dollars every month. And if you don't, then you breach the contract. And therefore, as a security for that, to protect the lender against that breach, you know, they can take your house. As everyone knows, that's what a foreclosure is. Well, so my very first foreclosure case, which really is the lead into pretty much the story I'm here to tell today, was a case in which there was, you know, you figure a foreclosure is pretty hard to defend. I mean, clearly we haven't paid. Clearly we signed these documents, you know, and our house is security for this loan. So what are our defenses going to be? Well, I wasn't sure what I could come up with, but I did notice that although my client had borrowed money from some bank, I call it ABN Ramrod. I have my little pet names for all the banks, but some obscure bank was the lender in the documentation, but yet my client was being sued by City Mortgage, Inc., and we didn't borrow the money from City Mortgage. So it was sort of a common sense kind of thing. I sent out a request to the other side for documents called a request for production, saying, show me the evidence that City Mortgage now has the right to collect on this promissory note, foreclose on this mortgage when I don't see the name City Mortgage anywhere in the paperwork. So, you know, I might be in debt, but if you're not the person I borrowed it from and you come to court and sue me, I mean, you're SOL, right? That doesn't fly. Just because I'm in debt doesn't mean that anybody in the world can just sue me to collect a debt that, you know, really is the property of someone else. So it was weird because they would delay, and I had to go to court a couple of times and ask for an order compelling the plaintiff to respond to our request for production. This was getting into...
Is that normal?
No, but there were so many foreclosures going on at the time, and these law firms... I was up against the law office of David Stern, which plays a big role in this story, but I didn't know it at the time. The attorney that was working for Stern, his name was Greg Dreilinger, and he would give me excuses, and he would play the nice guy, and I was still a little bit straight off the turnip truck. I had about 4 years of experience, and I grew up in the South, so I'm sure I was a little too trusting, or maybe a lot too trusting at that point in the professionalism and ethics of my opponents. So he would soothe my ire in court, you know, and be nice and talk about family and kids playing baseball and stuff like that, and effectively lull me into some degree of complacency. Oh, we'll get that to you. You know, I've just been busy. And you figure, you know, City Mortgage, Citibank, I mean, they're not going to be complete charlatans. I figured it was just, you know, paperwork. They're busy, whatever. But after I went back like the second or third time to get an order from the court, I started to get a little intrigued. And my client, who was an African-American gentleman, said, I don't trust him, Mr. Trent. I don't trust him. Well, he was right, because, you know, I was getting the wool pulled over my eyes by this, I call it the milquetoast persona, you know, and because I learned after a while, when I really understood how these foreclosure mills operate, I saw that this was a common tactic, a common personality. You know, they don't send in these ball busters to foreclose on people. They send in inoffensive people, you know what I mean? Sort of like customer service type personalities, you know, the milquetoast, like sort of bland and not inoffensive. under the circumstances, So they're like, oh, we know, we're going to work this out. And so I began to learn that this milquetoast persona was SOP for not only the law office of David Stern, but all of the other law firms that were doing foreclosures for the banks during this time. But I'm getting ahead of myself. So
do you think that that's because they don't want to come off as the big bad bankers that are trying to take your house from you, that this way they're like, hey, I get it. Like, I understand. They got behind. I feel for them. I got kids too.
Yeah.
Nobody wants to throw
You
them
would have
out.
been good at it.
Can we work this out? I mean,
Yeah, right.
And of course, knowing they don't have the money to work it out.
Well, not only that, but knowing that they are going to foreclose. Yes, that is part of the reason. But I think a bigger part of it is that they really didn't have what they needed to prove their cases at trial. Plus, that takes a lot more time, a lot more attorney hours, and they're trying to rush through as many foreclosures as they can as rapidly as possible. So they all hit the courts at the same time at the end of 2009. It's Florida courts. Mind you, I'm in South Florida, which is really the epicenter of the foreclosure thing. You know what I mean?
Right.
It was, I was in the right place at the right time and had the right case. So when I think eventually nothing happened in the case for like 6 months. And eventually we were set for trial, I believe in January of 2010. But just like in any civil case, before you have a trial in Florida, they send you to mediation. Mm-hmm. So we had to go to mediation. And this is where things started to get really weird. This is where the Twilight Zone experience kicked in. We went into the mediation and I'm figuring, okay, we need to just be nice and hopefully kind Mr. Dreilinger will work with my clients, because I didn't want to go to trial. I didn't really think I had any issues to really battle with.
Right.
And to be honest, I think that whole situation with that assignment of mortgage, what I had requested, might have slipped my mind, because thinking back now, I don't remember having that on my mind going into the mediation. I just remember thinking, we better make a deal. Time to make a deal, So I wasn't going in there being a ball buster either. I was going to bring my own milquetoast persona and try to work this out. But to answer your question, yeah, the real reason is because they can't prove their case except by using fabricated evidence. So any agreement that they can make, boom, they had it down to a science. They would say, oh, you need some more time, because everybody thinks they're going to get a loan modification, right, or some kind of reinstatement or refi. So they would tell the people, oh, you want extra time? How about we give you 90 days? Oh, yeah, that'd be great. Well, what the homeowners didn't realize is that they're agreeing to a final judgment being entered and just a delayed sale date, which, supposedly it's to give them time to modify the loan. But as we found out later with the national mortgage settlement and all the millions of dollars that were given to the big banks to encourage them to actually give loan modifications, fact is, that was all a charade. They were giving like 1% of people legitimate modifications, and the rest of it was all for show. Right. And what they really did was lull people into complacency by sending them these letters, making them think that the bank wants to work it out with them, sending in attorneys with the milquetoast persona, non-threatening, saying, yeah, we're going to give you 90 days. And by doing that, they were able to keep guys like me away from actually trying a case, actually forcing them to show up in court and present their evidence and present their witnesses, because they had a major vulnerability, which was, as I will explain more throughout this conversation, that they didn't have authentic, legitimate evidence to be able to foreclose, because all those original lenders, such as ABN Ramrod, I called them in that first case, they all went out of business. And this was all part of the big bank's plan, as I came to understand later. So if the company that you borrowed the money from is out of business, well, who's going to come to court and take my house? And there's nobody to even sign a document that says, okay, we're transferring this loan over to City Mortgage because the company is out of business. So they have a problem. You understand? Like, it could be an unenforceable debt, or at least an unenforceable mortgage. The debt might still stand because there are different rules with regard to debt collectors assigning things. But as far as the ability to take your house, they've got to prove that they acquired that from the original lender. And they weren't able to do that except by creating fabricated evidence, assignments of mortgage. So we went to the mediation, and there was Mr. Dreilinger and my client, and there was a submissive substitute librarian serving as our mediator, not exactly one that's going to force anyone's hand. She was the ultimate milquetoast. And then we have somebody there who's supposedly a bank rep, but he doesn't say anything. He doesn't have any authority. And when we try to get the loan reinstated and we make offers, this Dreilinger is going outside of the room and like whispering on his cell phone. And then he would come back in and say stuff like, well, if you want the specifics, I'll tell you. My client hadn't paid for like a year at this point because the foreclosure case has been going on for a year. There was, however, a case where my client's payments were not all applied correctly. So basically, their paperwork showed him owing about $600 more than he actually did. So one of his payments was not applied correctly. So we wanted to reinstate the loan. My client said, let's just get the loan reinstated. They admit they made a mistake with my payments. Let's just get the loan reinstated and have my same payments. And I said, yeah, we should be able to accomplish that. They're admitting they made a mistake. Well, when the attorney came back in from whispering on the cell phone, he said, no, that's against the investor's rules. We cannot extend the date of the final payment. So by virtue of the fact that they had not paid for 12 months, their monthly payment was going to go up because it's a shorter period of time now, to make the remaining payments.
Yeah.
So my client said, well, hell no. Why should I have my payment go up when it was their fault to begin with? I'm an advocate for my client. So I guess I've got to take that and run with it. That's a somewhat reasonable position in my opinion. I'm an advocate. So I thought, well, we're going to go to trial. And I have a lot of confidence in my trial advocacy, but at the same time, I did not have a lot of confidence in my case. So I'll always remember after that mediation was over, I know it was dark, and I was thinking, I've got to try this case in a month. What the hell am I going to do? And at that point, it occurred to me, did I ever get that transfer documentation that I was dragging them to court, 9 months ago to produce? And I went to my office and I had just a regular box and it was full of all their mortgage statements and everything. And there it was at the bottom. I guess after the second time I went to court, at some point, they had actually sent me an assignment of mortgage. And this is the document that changed my life. Okay. So that night after the mediation, I'm, stressed out. Like, what kind of a defense do I have to offer for my clients?
Right. Sleep quality declines in people as early as 30 years old. When you were young, your body was producing a good amount of sleep, regulating your hormones. As you get older, your body's ability to produce those hormones declines, making it harder to fall asleep and stay asleep. But nothing has moved the needle like Evening Being by Verso. After 3 years of perfecting the formula, they created a melatonin-free drink mix with clinically studied, patented ingredients. It's formulated to calm an active mind, help you fall asleep fast, stay asleep longer, and improve deep and REM sleep, all without creating dependency or causing morning grogginess. I look forward to drinking Evening Being every night, not only because it helps me fall asleep faster, but it tastes so good, it's become my go-to nightcap. Click the link in the description box or head over to Verso. That's ver.so, and use the coupon code COX to save 15% on your first order.
And I look at this thing, and it's like a gift from God. Or from Satan, one of the two. It's an assignment of mortgage, and it's supposed to say that the original lender is hereby transferring this loan over to City Mortgage, which would give City Mortgage the right to foreclose, the right to accept payments, and all of that. Okay?
Right.
Well, the signature of the officer of the original lender and the signature of one of the two witnesses and the signature of the notary were identical. Doesn't take a genius to go, might want to look into this. So I would just simply looked at the name.
So, and did the document say it was assigning it to Citibank from the original lender?
Yes, it did.
So there was no in-between party at that time?
Right.
Okay.
That's a good question, and we'll get to some of those in between.
Because that seems pretty cut and dry. If it would be cut and dry if you hadn't noticed the signatures,
right? If it weren't an obvious forgery,
right?
So the notary can't have the same signature as the bank officer who's signing it. So I just looked at the name of the officer, the bank officer, who's the name was printed beneath her signature, and I looked online. I just typed in her name, and the first thing I saw, I'll never forget, was full deposition of the soon-to-be infamous Cheryl Sammons. Because that was her name, Cheryl Sammons. And I'm like, wow, practically got a Woody. So I'm checking this out. And next thing you know, I'm reading this incredible deposition transcript where this awesome attorney named Thomas Ice Baby, had actually it was in my shoes a year earlier, only he was in Palm Beach and I was in Broward. And he had gotten suspicious about one of these assignments of mortgage. And he had brought in this lady who was signing them for a deposition. And he proceeded to ask her some questions. about MERS. Now, this is a very complicated aspect of the story, but it's very important. MERS is Mortgage Electronic Registration Systems, Inc. Now, it's not Middle East Respiratory Syndrome, although it is a virus, as I will explain, because it's a virus that affects the titles to properties of, Florida homeowners.
Florida, or is it nationwide?
Well, nationwide, but in my case, yeah, it is a nationwide thing. And what it is, you know how a company is sort of a fictitious person in the law? Well, MERS is like a fictitious bank. It's like another level removed from, we have a fictitious person and now we have a fictitious bank. And it's like metaphysical in a way because it's never had any employees. It's never had any assets, yet it's written into the language of 62 million subprime mortgages that were given to people, in the early 2000s, okay? So the same ones that were being foreclosed in 2009, 2010 in that area as a result of the Great Recession. So this lady's, but at this point in the story, it's best to just think of MERS as another bank, okay? And then we'll get into some of the truly diabolical aspects a little bit later. So this lady is signing this document on behalf of MERS. Just say MERS is standing in the shoes of the original lender. So when you ask me, was it from the original lender to City Mortgage, there was no other, actual transferee in between. However, MERS was acting as so-called agent or nominee for the original lender by signing this lady, signing it on behalf of MERS, because there's basically this gobbledygook sort of paragraph in all of the subprime mortgages. Maybe this is a good time to tell you about this, okay? So what I'm looking at here is a federal class action that I filed that has the language from the MERS mortgages. And, when you read this is a really ingenious provision because to judges, this is one of those things where you feel like you almost understand, and you should understand. And if you have the slightest bit of intellectual insecurity, it's kind of like the Emperor's New Clothes. Mm-hmm. It sounds really sophisticated and sounds like if you're a judge or a legal professional, you should know what this means. So I think people tend to pretend like they understand it.
Right.
When in actuality,
the Emperor's naked.
It don't make any sense. I don't make any sense, y'all. You know what I mean? Just to put it, from a common man's perspective. So just check this out. Parse this language a little bit. MERS is Mortgage Electronic Registration Systems, Inc. MERS is a separate corporation that is acting solely as a nominee for lender and lender's successors and assigns. MERS is the mortgagee under this security instrument. Not really. The mortgagee in Black's Law Dictionary is the bank that gets the payments. MERS never gets any payments. MERS is organized and existing under the laws of Delaware and has an address and telephone number of P.O. Box 2026, Flint, Michigan, telephone 888-679 MERS. Transfer of rights in the property. This is what was in all those subprime mortgages. This security instrument secures to lender, 1, the repayment of the loan and all renewals, extensions, and modifications of the note, and 2, the performance of borrower's covenants and agreements under this security instrument and note. For this purpose, no purpose was stated in the preceding sentence, borrower does hereby mortgage, grant, and convey to MERS, solely as nominee for lender and lender's successors and assigns, and to the successors and assigns of MERS, the following described property. And then it would give the legal description, and it would say, the subprime mortgages go on to provide, borrower understands and agrees that MERS holds only legal title to the interest granted by borrower in this security instrument, but if necessary to comply with law or custom, oh yes, MERS, of course, it's it's a routine, customary thing. Like what? MERS, as nominee for lender and lender successors and assigns, has the right to exercise any or all of those interests, including but not limited to the right to foreclose and sell the property and releasing and canceling this security instrument. Okay? So relying upon this completely, nonsensical word salad, gobbledygook, obfuscatory provision, they have 20,000 people known as robo-signers who would sign assignments of mortgage just to make it look like whichever company they're using to foreclose is the one who owns your mortgage, okay? And nothing could be further from the truth. It doesn't correspond with any real world transaction. It's just generated in the lawyer's office to facilitate them taking your house in foreclosure, even though they don't have the evidence and they're not the people that you borrowed the money from. You don't actually owe them, anything and without this. So, did you have a question?
No, I mean, the legal practice would be I go to Suncoast Credit Union, I borrow money to buy a house, I make the payments on the house. Suncoast Credit Union goes under. Mm-hmm. They go under, and during their bankruptcy, some vice president or president, someone who's authorized to assign those mortgages, assigns the mortgages to Bank of America.
Right.
Bank of America,
like happened with WAMU.
Right. And then Bank of America starts collecting those payments, and 6 months later, the person stops paying and they foreclose.
And Bank of America would be able to foreclose.
They would, because they've been assigned it. Right. But instead what's happening is that Suncoast Credit Union is nobody. They've gone under completely. All the vice presidents didn't get paid and said, go fuck yourself. I'm not helping you through their bankruptcy. That's your problem. And suddenly Bank of America is just stepping in and saying,
it's us. It's us. We're the ones who owe the money to.
Well, Suncoast Credit Union owes, or we're taking over that mortgage. Mm-hmm. And when you then say, okay, well, I need to see the assignment showing that you actually have an agreement with them or they assigned it to you, they say, oh, here's the satisfaction of mortgage. And instead of anybody at Suncoast
you mean assignment of mortgage?
I'm sorry, what did I say?
A satisfaction of mortgage.
Sorry. That's because
I can tell you some stories about that
too. That was my game.
Yeah, those are beautiful.
Yeah, instead of the assignment of mortgage, they provide an assignment of mortgage that was signed by someone who supposedly works for MERS, saying, hey, we've been elected to sign for the credit union, and we're assigning the credit union's mortgage to Bank of America. However, there's nothing saying that they were ever granted the right by the credit union to do this.
Right, correct.
So this is just me stepping in saying, here, yeah, I'll sign it. Yeah, here, it's been assigned to Bank of America. Right. And because all that does is say, who the fuck are you? Well,
right.
Well, I represent them. How do you, where's the
beef?
Where's the agreement with you and them and their assignment to you, giving you that power? Oh, that doesn't exist. You just have to take my word for it.
And when I requested it, that is the document that I got in my first foreclosure case, which opened up the window to me to realize that all these assignments of mortgage are fake. These things are being recorded willy-nilly in the official records by all of these foreclosing law firms, and every single one of them is a fabricated official instrument that's impairing title to somebody's home. It's a felony, man. It's totally fabricated. So when these banks come after you and say, oh, you've been scamming us on these loan applications, the fact of the matter is they've got the world beaten badly when it comes to fabricating documents having to do with mortgages. Ironically enough, Bank of America, Chase, Wells Fargo, all those guys, they're the biggest scammers of all, because every single one of these things is used to steal somebody's house. I mean, I had 1,000 of them at one time, and there's...
Okay, well let's go back to the person that was signing them. You said you looked at her deposition, and she's you're reading a deposition from a year earlier from another attorney, and what does she say in that deposition?
Well, he's asking her whether what relationship she actually has with MERS, what authority she actually has with MERS, what office she has with MERS to give her the power to sign someone's house away, basically with her signature. Because if she doesn't really have authority, that's why I said it's easier to just treat MERS at this point as just some other bank. She doesn't have authority, then this document is totally toilet paper, and they're not going to be able to foreclose. And Mr. Ice is going to be able to win his client's foreclosure case, and I'm going to be able to win mine. So that's why Mr. Ice was asking these questions. The question was, you have no job duties as an assistant secretary of MERS, correct? Because that was what it said under her name, like assistant secretary. But she also signed as vice president. All right.
It sounds like she notarized her own signature,
too.
Oh,
you think? Maybe just occasionally? The question was, you have no job duties as an assistant secretary of MERS, correct? I do not have any job duties other than signing the assignments of mortgage. Does that help? Yes, here, I'll try to rephrase this. Do you attend any board meetings at MERS? No, sir. Do you attend any meetings at all at MERS? No, sir. Do you report to the secretary of MERS? No, sir. Who is the secretary of MERS? I have no idea. Where are the MERS offices located? I can't remember. How many offices do they have? I have no idea. Do you know where their headquarters are? Nope. Have you ever been there? No. How many employees do they have? I have no idea.
Where does she work out of?
David Stern's office in Plantation, one of his 1,200 employees at that time.
So she's not even at Citibank.
No, she has nothing.
That'd look even worse, right? Like we got this chick in the back room assigning us, making these fake. This is like Bernie Madoff having like the guys on the 8th floor making all the documents.
No, they did. There's actually been testimony because this thing.
But I'm saying not in. They weren't in that bank. They're at the law office.
Right. Yeah. She doesn't know.
But so he knows. So he's not like it's not like he got these. It's not like he got this assignment and all this paperwork from his client, and he can say, that's what my client gave me.
Are you talking about David Stern?
David Stern. David Stern's actually got this chick in the back room making.
Oh yeah,
doing okay.
But it's not just that him and his law firm are some wild men that are doing something that's outside of the box for the big banks. Because no matter who they are representing and no matter which law firm it is, they all do the same thing. This was a standard practice across the country. This wasn't just some crazy lawyer. This is like standard. It's just. The law office of David Stern was a little bit sloppier, had a little worse case of hubris than some of the others. And I got lucky because this one, was so obvious that it opened the window to make me delve further into it. So I actually, in my first foreclosure case, I ended up getting to take the lady's deposition myself and ask her. And I got Mr. Ice's depo transcript like under the table, reading half the questions back to her and getting totally different answers, of course, because
now she's been coached or what are they called?
I don't know, but she was all over the place. So
this is back to the original one.
Yeah, we're still in the original case. So I don't know if you want to hear some of my questions to her, but they were pretty earth shattering as well.
These are yours, or I thought you were reading from Ice's.
I'm actually reading from the federal lawsuit that I filed in 2010.
Oh, okay.
And where I quoted Mr.
Her.
Ice's because I took her deposition before that in the foreclosure case.
Okay.
So that's why that's both in the same document.
Yeah. Go ahead.
Yeah. So, it's long, but I'm trying to figure out what's the best excerpt to use. Let's just start from the beginning here.
Run it.
All right. So I asked her about the assignment of mortgage, in our case.
Right.
I asked her, it says, but effective as of the 19th day of February, 2008. Do you see that? Yeah, that was another thing. It was backdated by a year because they needed it to be before the foreclosure action was filed.
Okay.
Okay. So even though it was supposedly notarized in 2009, it says, but effective, this backdated to February 19, 2008. Do you see that? Yes. Where did you get that date from? I did not pick that date. That date was put in by the processor that prepared the assignment. And who was that? Off the top of my head, I do not know who actually typed this assignment. Okay, but you're signing on behalf of MERS, and you are stating here that it is effective as of the 19th day of February, 2008, correct? Correct. At the time you signed this, what reason did you have as agent for MERS to make it effective as of the 19th day of February, 2008? I did not pick that date, and I do not recall this document. Sitting here today, you have no idea why it is that it says effective as of the 19th day of February, 2008. Is that correct? Looking at this one particular piece of paper, I do not recall or know the answer to that question. No. I want to skip to the part about, it says in all these legal documents, you have to have something called consideration, which is, if you make a promise to someone and you're not getting anything in return, that promise is considered gratuitous and it's not enforceable in court. Right. So there has to be an exchange of value called consideration. Exactly.
Something.
It usually says $1 or $10 in the assignments. And so this is when I asked her about that. I said, if you could go back, please, to Exhibit 2, the assignment of mortgage. We're on the first sentence of the first paragraph. You see where it says, for and in consideration of the sum of $1 on the second line of that paragraph? Yes, I do. Did you pay that dollar or did you receive that dollar? I did not have anything to do with any money exchanging hands on these assignments. Okay, so when you signed this assignment, did you take any steps to determine whether or not this $1 actually changed hands? No. Do you know of any information that would establish that this $1 did or did not change hands? No. Who would I ask to find out? I have no idea. It says other good and valuable consideration. Do you see that? I do. In executing this assignment for and on behalf of MERS, can you tell me what other good and valuable consideration there was that gave rise to this assignment? No, I cannot. Do you know who I could contact to find out what the good and valuable consideration was? No. It says the receipt of which is hereby acknowledged. Do you see that? Yes, I do. Did you acknowledge receipt of that $1 and other good and valuable consideration when you signed this document? No. So when it says the receipt of which is hereby acknowledged, is that an error? I have no idea. Okay. So this lady is vacuous. She doesn't have the slightest clue. She's just in a room. This is the testimony, literally, where they're signing 2,000 of these per day. They have like 2 days a week that's just signing day. And it's her and some notaries in there, and they're just signing. They're signing willy-nilly. It's whatever the lawyer put together for them. So the biggest thing is that this wasn't just an isolated practice of one outlier. This was standard procedure handed down by all the big banks. And that actually leads us into the realm of the truly earth-shattering secret that this is all designed to hide. Mm-hmm. Okay. And that is that nobody owns any of these loans, and all the securities that were sold, trusts, RIMICs, real estate mortgage investment conduits, all these securities that were sold, many of which were sold to the government for employee retirement accounts, for federal workers, states, same thing. They're all worthless, okay? Because none of the loans, there's a thing called securitization. I know you and I spoke about it briefly, and it's pretty technical, but for your viewers to really understand the significance of all of these fraudulent documents, you have to understand a little bit about securitization. Just like so many things with the banks, it's almost like they have a sense of humor with the terms that they use, Like securitization. I mean, if anything is insecure, it's this process of securitization, what they do is, the reason that they started approving everybody, or, making these stated income loan applications, all that, having such relaxed standards, basically they invited guys like you, Matt, to just get them something that they could ostensibly, with a straight face, approve, so that they could have more loans, because what they did was, the way that they were actually making money on these subprime loans was not to have you pay your loan over 30 years. That's the last thing they wanted to happen, and that's the last thing that they intended to happen. What they intended was for you to default. One of the things they used to do that was the adjustable rate mortgages. Start out with a nice payment, $800 a month. What's the big deal? No problem, I can handle that. And then, 2 years later, it's $2,500 a month, but your realtor, your mortgage broker were telling you, oh, by the time your rate adjusts,
we'll refinance it.
The equity is going to go up, and you'll be able to refi. You'll have equity in your house again.
Every 6 months, sometimes 90 days.
And for a while, that seemed to work.
Yeah, every 90 days, every 6 months, it would adjust. And so your $800 payment, 6 months later, suddenly it becomes, $905. And you think, okay, it's not that big of a deal. 6 months later, it becomes, it's 1,080. 6 months later, it's 1,201. And then if you really look at it, you're like, okay, it's been 18 months. My payment doubled. Like this is insane, And then it keeps,
and then they have to come see their mortgage broker again.
Right. And of course they got a 95% LTV loan.
Right.
They could refinance if it was an 80% LTV loan, but in 18 months it hasn't gone up by 20%.
Right.
So it's that they've got a problem.
Yeah. Especially when the bottom fell out.
Yeah. Which when they started this process was about 3-4 years before 2008. So by the time it became overly obvious to everybody involved, that's when, and these people can't refinance. That's when everything,
right?
The bottom fell out, and it was just a straight shot to the bottom.
But what I've learned in my career as the foreclosure destroyer, though, is that that's all actually part of the bank's plan, because their money was really made on securitization. The more loans that they have that ostensibly meet certain criteria, the more securities they can sell in these trusts, also known as REMICs, R-E-M-I-C, real estate mortgage investment conduits. These real estate mortgage investment conduits or trusts are the beneficiaries of an exemption given by the IRS in advance of all this scandal taking place, to allow the banks to have these trusts, which are tax-exempt entities, okay? Now, the only way that they can maintain that tax-exempt status is to acquire a certain number of loans, like 1,000 loans, by a certain date. And to acquire them, these are all part of the IRS regulations, they have to get the original blue ink, we called it, promissory note transferred to the designated trustee of this particular trust. So all the loans in the trust would say they would be marketed to investors. The trust would be marketed to investors. For example, these people all have 70-30 ratio or less. You know what I mean? They have at least 30% equity. over and above their loan balances. They have 700 credit scores, whatever. So these are highly qualified borrowers that are highly likely to perform. These mortgages, these loans are likely to perform. That's how they would market it to the investors, namely institutional investors like the federal government, buying this stuff up so that it can be placed in their employees' retirement funds. Thereby, their employees, when they retire, have a reasonable income from these investments. Well, the thing is, they actually also lobbied the Securities and Exchange Commission to change some rules about how these trusts are audited. So basically, they don't have to identify ahead of time which loans are in which trust. So that enabled the banks to take one loan and at any given time claim that it's in any given trust if there's any questions about this trust or the assets that were acquired by this trust. And to do that, they end up needing to fake documents because, it was a big thing. Everybody was getting approved. It was like they were overwhelmed. It was a boom cycle. So none of the loans were getting transferred. None of the original promissory notes were transferred to the trustee by the closing date. I mean, that almost never happened. So that means that if the government finds that out, they're going to lose their tax exemptions, and all of these trusts, which there are thousands of them, and they're at least in the tens of millions of dollars, even the smallest ones, and some much, much more than that, it's a 100% or 99.9% tax penalty if there's any transfers into the trust or out of the trust after the closing date, which is the date by which all the loans are supposed to be acquired. So, Joe Schmo gets a loan, and then that loan, theoretically, the original documents are transferred to the trustee, and then there's all this complicated paperwork called a pooling and servicing agreement, which allows the trustee or servicers to collect all the payments and then distribute pro rata shares to the investors in this trust or this REMIC. Well, none of the loans were transferred, so what has been sold to the federal government, this is why the Bush administration, the Obama administration, they did the same thing. They didn't go after these guys when all the shit hit the fan. They went after, I mean, no offense, but like small guys like you. You're a small guy compared to like, Ben Bernanke because I really think that the Fed was in on this, but that's a little bit of conspiracy theorist, and I don't have the evidence of that. Everything else I'm going to tell you, I have the evidence, so we'll leave that one alone as far as the complicity of the Fed itself.
So I have a quick question. Did you ever see The Big Short?
No, but I've heard that it's quite similar to.
It's great. It's great. Yeah, it's a great. You'd love it. I can't believe you've never seen The Big Short.
Well, I lived it myself, and I really didn't want to influence my story with watching all these movies that are talking about sort of the same thing that I'm talking about, because then it's kind of like the authenticity gets diluted. Maybe I'll accidentally start bringing in some of these concepts that I got from these movies, and it'll sound like I'm just spouting rhetoric from having watched one of these movies a couple too many times.
No, I think it's good. It's funny. Did you ever see?
I've been told to watch a million times The Wolf of Wall Street.
That has nothing to do with this. But
I've heard of there's another one too.
Yeah. Too Big to Fail.
Yeah.
And that's a great one because it gives you a macro vision of what happened. You know what I'm saying? Like from all the people at the top, where from the first phone call to what's going on. You know what I'm saying? Like it's really amazing, and the deals they're making behind the scenes, they're pleading to try and get this bill passed. They're like, you got like, Congress is arguing, the president's arguing, like everybody's arguing. Ben Bernanke's arguing.
The bailout and all that.
Yeah, that's what I'm saying. This is up
Disgusting.
to the bailout, but
I hate the bailout.
They're sitting there and they're arguing, and these guys are not understanding the detriment of what is happening to the company or to the country. Sorry, and you've got these senators like, I'm not doing this, and they're like, you don't seem to understand what's about to happen. Like, you've already got credit drying up. Like, companies aren't going to be able to make payroll unless we do something. So it's interesting. You'd probably, and you might watch the whole thing and say that's not possible. That's not what happened. That's not why they did that. You may have a completely different take. But anyway, can we jump back to, because we kind of got off track. You did the deposition with her. Like, what ends up happening with your case?
Well,
or these guys? I mean, do they?
I filed a motion for summary judgment showing the judge that this was a fraudulent assignment of mortgage and seeking sanctions, and they did a voluntary dismissal of the case. And as soon as they did that, I started pulling people together because...
Well, what does that mean? They dismissed the case. They dismissed the foreclosure case
Correct.
against your client.
Yes.
So what does that mean for your client?
Well, as the law has developed since then, it doesn't mean that much, because they can turn around and sue you over and over again and just say, oh, we want to do over, dismiss that one, and then come after you again. Of course, he gets his attorney fees. So I got an attorney fee award for my client, like, $20,000 or something like that.
Right.
But they would have the right to sue him again. That's
doesn't seem right.
Because of all of this, that is basically the way that all these foreclosures glutted the system, and the way that all these scandals arose from these fake documents and everything, because this ultimately did turn into a fairly big scandal in 2010, the robo-signing scandal. And the Florida, but you were trying to lead me back to discussing like what happened with this case and where it went from there.
Yeah, but I mean, she basically, she's admitting, I do have another question. Is she getting a check from MERS?
No, MERS has never had any employees and never had any assets.
So how can you say I represent MERS and I'm an employee of MERS and I'm authorized to sign these documents on behalf of MERS if I don't even work for MERS?
It's a fiction. It's a fiction that some evil geniuses dreamed up to justify this practice of robo-signing.
So who's she getting a check from?
It's from David Stern.
Okay.
See, he's getting paid well by Fannie Mae and Freddie Mac and all the big, banks. And
so was I. They said it was fraud when I did it.
I know.
I had somebody in the back room.
That's why I'm such a good match. I'm such a good match for your channel, because everything I say here exonerates you. It makes you look like a better and better guy.
Yeah.
I mean, you haven't even Bank of America, man. I could do a week on Bank of America. I mean, Skank of America is what I call them. Too bad I don't have my bumper stickers anymore since they.
That's so funny. That's the same signature. That's the same signature.
Yeah, but these are both me and my bar complaint against
This
David
is
Stern.
you?
Yeah. But look, they're the same. It's allowed to be me. They're both Kenneth Trent.
Where's hers? Hers looks just like your signature.
No, it doesn't. Now we're going to need a side-by-side comparison from...
this is hers?
Yeah. Plus, it's the signature's over different names. Mine's over the same name. Mine's over my name.
Okay.
This is...
Yours looks kind of similar to this.
Okay, I'm a robo-signer. This is
I'm just saying,
all a charade.
It's very swirly.
I'm actually very undercover.
Okay,
this is what happens when you have to sign 2,000 a day and you're. I asked her questions about that. Like,
does she have her own notary stamp?
Yeah.
Like, who's notary? How are you signing for the notary?
She's just stamping and signing. It could be they have all different notaries. The stamps are all out there on the table, and anybody who's working that day can just come in there and sign them all and put any stamp that they want. That's the testimony. And it wasn't just at this law firm. It was also at Marshall Watson, whatever the other, Florida Default Law Group. Just like the big banks, they like to change their name every so often to get out from under the whatever heat is coming their way. These law firms. But so yeah, I should tell you though. So I ended up understanding that they've stolen. David Stern's office has stolen 100,000 homes in Florida with these fake documents. Something needs to be done. I mean, it says right here, the law office, it's David J. Stern prepared it. So there was no question of, who is responsible for these. So I was getting ready to file my class action. I wanted to file a class action to do something for all of these homeowners that were getting scammed, by David Stern's office and the other law firms. And so to me, it was perfect RICO. But before we got to that, I got a call from the Florida Attorney General's office. At that time, it was Bill McCullum. I didn't hear from Bill McCullum, but his two right-hand attorneys, his two assistant attorneys, Teresa Edwards and June Clarkson, they actually got interested because, oh yeah, that's what happened. I ended up filing a RICO suit against David J. Stern and MERS, and immediately thereafter amending it to add all of the shareholders of MERS, which is like the full, gamut of Bank of America, Skank of America, Untrust, Citibank, Wells Fargo, Dewey, Cheatham and Howe, double wide home loans. But no, it was Fannie Mae. Don't even need to change anything with that.
Right.
Freddie Mac. But yeah, so I ended up filing a RICO lawsuit, Racketeer Influence and Corrupt Organizations Act, and I put it out there on the internet. And it was July 26, 2010. And I really felt like, wow, I've made it. I mean, I remember I had tears in my eyes when I filed that suit because I knew that I felt like God had blessed me to be in the right place at the right time and to land on this huge secret that's going to change the world and, it's going to make my life a lot better because I basically had I don't want to say poverty stricken, but I had my times as a child that I was living in poverty, with no running water because the pipes froze in the winter. And, my mom was pretty poor. So I definitely wasn't from the advantaged socioeconomic class. So I was feeling that this was a blessing and I was going to be able to do a lot of good for a lot of regular people, a lot of the 99%. I was going to wreak some vengeance on these scumbags, which is what I always wanted to do. I actually, when I was in law school, I used to watch these shows, American Justice, where innocent people would be in jail for 10, 20 years, and then finally they would get exonerated by DNA, and I wanted to go to law school so I could bust the corrupt cops that were framing people and putting them in jail for crimes they didn't commit.
Right.
But then I learned about this, and this was like, they're way worse than corrupt cops. They have way more power, actually, to destroy more people. I mean, the number of people that had relapses, the number of marriages that broke up over these foreclosures, you know what I'm saying? The human destruction,
stressful.
Human destruction is off the chart. So there was a whole racket of, oh, you're going to get a modification, string them along, and then they don't get a lawyer because they need to make their trial period plan payments, like $1,200 a month for 3 months. Well, they could either hire a lawyer to defend a foreclosure that common person doesn't really think they have a defense to, or B, they can take that money, pay these 3 trial payments and get a modification. So what would happen is people would make the trial payments and then the deadline for them responding to the lawsuit would pass. And then they would get a default because the person didn't hire an attorney, didn't respond to the lawsuit thinking it was taken care of. And then boom, they would be informed, oh, the investor, there we go again with that term, doesn't approve.
Right.
Didn't approve.
Not knowing that the investor had to sign off to begin with.
Right.
Like, you just said I had to make 3 fucking payments. You didn't say somebody else had to approve.
Yeah, that was just like that investor that was I was being told about in that mediation. Like, this is supposed to be, last I checked, it's supposed to be a plaintiff and their lawyer, defendant and their lawyer. Who is the investor? Why is this person I can't identify, throwing my clients out of their house? You know what I'm saying? That's against our system of justice. You're supposed to be able to confront your accuser, you know what I mean? And challenge them. So we don't even know who it is. It's like somebody behind the mask. And really, it was someone behind the mask of MERS, I later came to understand. Because they can do anything they want to you and just wear this MERS mask, and you can't tell who the hell you're dealing with. It's not Cheryl Salmons. She's not who's making these decisions.
Right.
You know what I mean? You can never, ever pin it down. So that's what this robo-signing and stuff is designed.
So you file your class action lawsuit.
And then we got a call from the Attorney General's office. And they wanted copies of everything we had. And there were, I don't mean to say that I was the only person on this. There were, I don't know, I hate to use a really dated quote from a president, but 1,000 points of light, like George H.W. Bush mentioned once about, I guess people doing charitable works. Well, it was 1,000 points of light of litigants and attorneys all over the country getting suspicious about these shady documents and these horrible practices and the scam of, oh, you're going to get a modification. Oop, no, you aren't. And now it's too late. You've already got a default against you. The case is over. The foreclosure sale is in a week. Good luck. Right. So the Attorney General, Bill McCullum, God bless him, went after these law firms, pretty aggressively. And they had press conferences with McCullum and Edwards and Clarkson, and they are conferring with me all the time. And they went after, they filed suit against David Stern and Marshall Watson and the 2 or 3 other firms that were doing this in Florida, this kind of thing. They put together a huge, I forget what it's called. What is it? like overhead. I mean, what's the
presentation and
it was
overhead?
It was a PowerPoint.
PowerPoint presentation.
PowerPoint of like, all these fake signatures and Linda Green and this person doesn't work for this bank. And you had this scandal sort of breaking. So I was able to, when I did my federal lawsuit, I was able to take not only from what I had learned in my short period of time defending foreclosures, but stuff was coming about and being compiled on the internet, like Mr. Ice's deposition of Cheryl Salmons. Somebody had actually taken the deposition of the MERS CEO, William Hultman. That one was an eye-opener, which maybe we'll get to today or another time. I mean, this guy, the stories, the word salad, the ambiguity that spews from his mouth, the misdirection is just, it's like record setting. You know what I mean? This guy talks more double talk than anyone you could imagine, any caricature.
So the Attorney General's office, they do the PowerPoint presentation. They file a suit. They start deposing people. What happens with that?
Well, among those depositions was the one where there was testimony about 2,000 of these being signed daily and 2 days a week, and people just having any random notary stamp anyone can sign. They just have a pile and they have to sign them. And people like Cheryl Salmons, she started out writing her signature, but then after a while, it just got ridiculous and it turned into, because she has to do so many of them, I'm sure her hand probably hurt. And so this scandal sort of was breaking nationwide. And I filed this lawsuit. I had the Florida Attorney General basically on my team. I mean, help, fighting the same fight that I'm fighting from a more official position. And, things were going well. And I wrote that lawsuit. It fit RICO perfectly because it's basically when you have a criminal enterprise, it's a business. It looks like a legitimate business, but actually it's part of a criminal conspiracy. And they use the mails and the wires to transmit documents. And they commit any of the number of predicate acts, such as wire fraud. I mean, fraud, it's fraud.
Right.
All day long, it's fraud. So basically, I had a great case with that. And so what we wanted to do was recover triple damages under RICO for all of the class member homeowners who got their homes stolen through the court system by perversion of the justice system by feeding fake evidence into the process, fake instruments, and recording fake instruments in the official records. So it was good, and I ended up on the national news, not CNN, not Fox, not the ones controlled by, the 1%, but it was PBS NewsHour, and I think Trump needs to lay off of PBS because they did at least carry this story about MERS and this robo-signing, because I was one of the few to actually see that or declare that MERS is designed simply to run this huge fraud relating to securitization, because it enables them to create ownership documents for any loan, for any entity at any given time. Voila, it could be out of business, never existed in the first place, doesn't matter. They can simulate ownership of a mortgage by a particular entity. So I got on the national news on PBS NewsHour. And you're not going to believe this. Your viewers may not believe it. I could be wrong, but I'm pretty sure that the person that appeared in that episode on PBS NewsHour from October 10 or 12 of 2010 was an actor. Like, he's supposed to be the CEO of MERS, okay? But the guy's name, and you can't make this stuff up, is R.K. Arnold, like Benedict Arnold, from the history books. And then R.K. Arnold, which is like John Grisham, all the bad guy attorneys, they always have those first initial and then middle name and then last name, you know what I mean? And this is pretty much the same kind of thing, R.K. Arnold or something, those initials. So I think it was like the dumbest possible, most malleable guy they could find with a law degree, because he has a law degree. I looked him up from South Texas College of Law, the same, strangely enough, as David Stern. So here's this hillbilly with a high and tight haircut on PBS NewsHour, and they've got this phone room with just a bunch of computer monitors in the background pretending like that's MERS. MERS doesn't have any offices. I have the testimony of the real people behind it, or some of them. It doesn't have any offices, it doesn't have any employees. This is all a complete charade put on for the news. And here's this guy, R.K. Arnold, talking in this podunk accent, And he's being asked by somebody from PBS, what gives MERS the right to foreclose? It's the mortgage. It's a standard provision that all the borrowers agree to when they sign the mortgage. Nobody knows what the hell that means, or nobody's agreed. It's certainly not a standard provision. I mean, it's non sequitur after non sequitur. It's Greek to me, as they say. So, that I thought I made it. You know what I mean? I'm riding high, and I had filed a bar complaint against David Stern because, well, I thought that's what I was required to do. It's not because, I'm some holier than thou or just wanted to, be judgmental or just bully someone. Fact is that I'm still going to court like in 2010, 2000, and I'm still seeing the same crap go on every day in the hallways with these attorneys pretending to be nice to the homeowners, getting them to agree, when really the bank doesn't have the paperwork. They're presenting fabricated evidence all day, every day in court. And I mean, I believe that stuff they taught in law school about ethics. And I really, I was naive, I guess, but I thought there's a law that says there's a rule of ethics that says if you know an attorney that has like an ongoing criminal activity, you as another member of the bar are supposed to turn them in. You're required to turn them in. So I filed a bar complaint against David Stern on August. I do need to look at this somewhere just to get the date. It was August 10, 2010 when it was received by the bar. And I just gave them samples of those assignments of mortgage. They all say prepared by David Stern. And I said, hey, you need to look into this. They're using fabricated evidence to foreclose on people, all day, every day. So we went to federal court and we got a judge by the name of Cecilia Altanaga, who's now the chief judge of the Southern District. Man, I don't know how to explain it. I just knew I had him right. So it's little old me with my GED and my class representative, Damian Figueroa, versus all of Wall Street, pretty much. All these big law firms, and, it's just little old me next to the fetish factory in Oakland Park, writing these briefs and going against them. And I thought it was great because I was in the right, and I could, I knew it was a $7.5 billion lawsuit on its face because they foreclosed on 100,000 homeowners in Florida with fake documents, but we get triple damages if we win. So if you foreclose on a $250,000 house, that's $750,000 for that one person.
Right.
Okay. And then we conservatively estimated that we could get 10,000 class members, which would have been $7.5 billion. Okay. So It was fairly high stakes, involved here. So we set about litigating it. And one of the arguments that the banks came up with was, well, you're trying to overturn these state court foreclosure judgments in federal court. And the federal court is not an appeals court for the state court. So this case has to be dismissed. You can't appeal the foreclosure judgments. But it's clearly obvious from the complaint that's not what we were doing. We're seeking damages. We're treating the foreclosures as a fait accompli, like accomplished. It's over with. All right.
There's nothing we can.
Nothing we can't claw back. It's already been sold.
We can't throw the people that currently live in that house out and give it back to our clients. That's dead.
We were way smarter than to try to do something like that. So
even if it was done illegally, it's done.
It's done. It's still a final judgment. Right.
It's like a guy that gets found guilty of murder and 20 years later he's found innocent. Okay, well we can't reverse time. Right. I can't give him the 20 years back. Right. I'm asking for damages.
Yeah. Plus, these homes by this point have been sold at the foreclosure auction, sold by some of the realtor, so there's all kind of innocent people whose rights are, we were never going to do that. That's why we have RICO. We're suing for damages only. We're not suing to get the houses back. So ultimately, to make a long story short, the federal judge Altanaga, she ruled in a way that none of the bank's awesome lawyers even came up with. They were trying to have the case dismissed under Florida Federal Rule of Civil Procedure 12B6, which is basically, the court has to take all the allegations of the complaint as true and then determine whether they state a cause of action. Well, 12B1, something like the court doesn't have to take the allegations of as true and can figure it out for herself. I don't know. It's some kind of obscure provision that's not very often used in federal court. It's not an argument that any of the banks were making, but yet that was the provision. That was the basis for Judge Altanaga's decision, and we're trying to overturn the state court foreclosure judgments. And we can't do that because we have separation of the federal system from the state system, and the federal courts cannot overturn the state court foreclosure judgments. Nobody was asking you to do that, but that was the fiction that caused, or that was the articulated basis supposedly for her 35-page opinion. And if you actually read it, she'll make one claim, about our case. And then a few pages later, when she quotes another section of our complaint, it disproves what she just characterized. You know what I mean? Like the whole opinion really collapses on itself because what she's saying isn't true. We weren't trying to overturn the state court judgments. Never had that in mind. So that's unfortunate. But I think I understand now that really that was a factor of too big to fail. We can't let this case go through because if it does, what's it going to do to the economy? All of Wall Street's going to collapse. Right. Horrendous. Well, sometimes, I think every time there has to be pain before there can be gain, and I'm sure there are plenty of geniuses in this country that can come up with alternative systems of government, and everybody would bounce back. There would be, if all of Wall Street collapsed, there would be alternative ways of running our economy. You know what I mean? With like Bitcoin and all that. I mean, cryptocurrency, obviously Bitcoin's a bit of a dated reference. It's not Coca-Cola for all. It's not Bitcoin for all. It's not whatever. It's not Chat GPT for all AI. You know what I'm saying? Anyway, I filed this bar complaint against David Stern, and the Florida bar is taking it. Of course, there were several other complaints that had been filed about him. And they were like, the Florida bar was like exchanging emails and information with me. And I would get another transcript of some other former Stern employee, and I would send it to them. So David Stern never offered me anything. They just came into court and pretty much had no shame with the BS. Like this is standard industry practice. Well, that doesn't mean it's not a criminal enterprise. I was
going to say.
Not a very good argument. And so David Stern was in some trouble. And then in October of 2010, I really feel like I contributed greatly to the nationwide foreclosure freeze, because right after that PBS NewsHour thing came out and the story was building in the news, this robo-signing thing, next thing you know, it's all the big banks have announced. Bank of America announces that they're freezing all foreclosures to check and double check and verify the paperwork. So it was kind of a blip on the screen. It only lasted about 10 or 12 days, but they were putting on this charade that they were going to go through and evaluate all the paperwork. Oh, we haven't found anything that affects anything, just a few discrepancies with a few notaries or whatever, And at this point, actually, because of the Florida Attorney General's investigation, the 48 other state attorneys general started similar investigations of these foreclosure mill law firms in their states and the big banks and the servicers. And that very same trend ended up in the national mortgage settlement in 2012, which did require by its terms, Bank of America and Wells Fargo and all these banks had to give like a certain number of modifications. They got a huge amount of money from the government. So not only did they get the bailout, they got money from the government as part of the national mortgage. Well, they had to pay, money to the government, but there were all these incentives where if they gave a certain number of modifications or processed a certain number in good faith, then they wouldn't have to pay as much. But, I think it was $12 billion or $12 million for Bank of America. That's a joke. Now the attorneys general could go to their voters and say, look, we got Bank of America to pay $12 million. Do you think Bank of America gives a rat's ass about $12 million really in the overall scheme of things when we're talking about a nationwide securitization regime where they're selling air to institutional investors all over the world? I mean, they make so much more money off of that. They act like, they fight it tooth and nail, and they act like 12 million is going to hurt them and they need a bailout. Bank of America paid back its bailout like extra early with interest. It's not, they're so calculating, they didn't need to be bailed out to begin with. They were the ones that orchestrated, not just Bank of America, but all the big banks. They orchestrated the boom and bust cycle. They've been doing it for hundreds of years, okay? They make money on the way up when the market's on the way up, and then they stop approving everybody. They raise the interest rate, the market crashes again, and they have everything set up in just such a way that they make money on the way up and money on the way down, and they are intentionally orchestrating collapses. That's what these big banks do. And so in my world with securitization, I call it faux securitization, like fake, because there's nothing there. There's nothing in any of these trusts, yet that's the biggest asset that our government employees have in their retirement accounts. Well, guess who else has to worry about their retirement accounts? Matt, judges. Okay. So if the judges start throwing out all these foreclosures and saying, oh, look at this is all fabricated documents and referring people to the state attorney's office, well, what's going to happen to their retirement when they retire in 5 years? And now their retirement fund is totally gutted.
Right.
Because there's been a big scandal.
So there's a conflict of interest.
Right. Oh, huge. But I wouldn't put it past the banks to have actually, that's part of their plan. You know, these judges, I learned over the years, they have a tremendous bias in favor of the plaintiffs in these foreclosure cases. Like, seems like no matter what you show them, most of them, you know, they just wouldn't listen. They would pretend to listen and then just go ahead and give the bank the house anyway. You know, no matter how much fraud you proved, they would just turn a blind eye to it, time and time again. Now, there were other attorneys like myself who became, you know, really prominent in this area. We have Mr. Ice, of course, Bruce Jacobs out of Miami, Mark Stopa out of Tampa area, and Matt Widener out of the Tampa area, to name some of the primary ones. And ultimately, so let's get back to the David Stern bar complaint. So after like a year, the Florida bar had not done anything to David Stern. He still had a law license. Here we are in February of 2011, or after that, I think, more than a year from the time I filed the complaint. And I'm going to court every day, and I'm still seeing the same tactic, the same crap, the same fabricated assignments of mortgage. He's still in business. I thought it would be an emergency suspension order by the Florida bar, but they've basically done nothing in a year. They've collaborated with me and gotten information, but they haven't done anything to him. The case is just lagging there. So, mistake of my life, I guess, I wrote a letter to the bar prosecutor who was handling the case against David Stern. Her name is Adria Quintella. She's now a law professor at Florida State. I wrote her a letter, and I began it with niceties. I was polite, but I said, you know, but then it got a little bit less polite. I wrote, I am simply floored that the bar has taken no action against David Stern after the passage of more than 12 months since you received all the evidence you would ever need to know that this guy is basically a danger to the public, a criminal that must be stopped. I didn't say that part, but I said, I'm floored the bar has taken no action. Several people appear not to be doing their jobs. And if you're not the person to whom I should address my concerns, please tell me who it is that I should write to. I didn't send it to the bar's board of governors. I didn't send it out to the media. I just sent it to her, and I was forced to copy David Stern's attorney because you can't unilaterally communicate, you know, in that situation. Right. You have to copy the other side. But she never responded to that letter. Like 8 months after that, they finally announced they were moving ahead with the case against David Stern. I got interviewed by the Palm Beach Post, and I'm quoted in the Palm Beach Post as saying, I was greatly relieved to hear that the Florida bar is doing its job. And these people, well, they still teach you about ethics in law school, and these people made a mockery of it. That was the quote. Well, when it was time for David Stern's ethics trial, I was supposed to be the second witness, but the night before, they sent me an email and said, we won't be needing you, Mr. Trent. Okay, but I still went and watched because I was vested in this. And they sort of like eliminated all the allegations about the fabricated evidence, and they just were presenting stuff in Stern's ethics trial about, oh, his associates didn't show up for court, or they didn't meet deadlines, you know, they didn't respond to subpoenas, whatever. Basically convicting him of gross negligence rather than the rampant criminality that he was actually, you know, perpetrating. So that was unfortunate, but I didn't understand at the time, but later on I came to understand. So he got finally disbarred in 2013. And I went on practicing law. We lost the federal case, lost the appeal. That was unfortunate, but I was still the foreclosure destroyer, had a good reputation, and had a lot of business, and you know, I was practicing law. Well, ultimately, the Florida bar decided to come after me. All right, and they bided their time. Adria Quintella waited her chance to go after me. I think largely because of that letter and that article in the Palm Beach Post, which she undoubtedly read, and she could have interpreted it as being much harsher criticism than it really was. When I said these guys made a mockery of ethics, the preceding sentence I did reference the Florida bar. If she's inclined to interpret it, you know, in a negative light, she could. But
I was assuming you meant.
I did mean David Stern. I most certainly did, and I didn't say. You know, I didn't tell the Palm Beach Post, I wrote her a letter a year ago and they still didn't do shit. I mean, it wasn't like that. That wasn't my intention. I know better than to completely antagonize the bar, but I should have never written that letter because, unbeknownst to me, it appears that this lady, who eventually became the head of the state bar prosecution division, like the head of the disciplinary wing of the Florida bar. So she's in charge of bar discipline for the whole state.
Right.
Okay. By the time 2020 comes around, and I end up pissing off a bankruptcy judge. The guy was like 80 years old. My client was the only African American in the room. I don't know how much time we have, but basically, my client's bankruptcy attorney had given away her house in the bankruptcy in the Chapter 13 without discussing it with her. That was what my client explained to me. So I simply came into the bankruptcy case and did a sworn motion signed by my client that my client never agreed to surrender her primary residence. The whole reason she declared bankruptcy to begin with, Chapter 13, was to keep her primary residence, and her attorney did that without her knowledge. So that would be a basis to set aside the agreed order of the bankruptcy court surrendering her primary residence to the bank. And we had several hearings in front of this federal bankruptcy judge named Raymond Ray. They don't have a retirement age. I believe he was over 80 at the time. And ultimately, my client testified. Her former attorney, who this point is very defensive, she thinks she's going to get a bar complaint because she gave away my client's house, which is not an unreasonable thing to anticipate. However, she never got one. That wasn't our plan. I'm just trying to protect my client. I'm not Robin Hood out filing bar complaints.
You're trying to rectify the situation.
Yeah, absolutely.
For your client.
But of course, the attorney comes in there and says, oh, yes, we discussed this in depth. And the judge is 80 years old. The attorney's whiter than my client. The judge is from Alabama. He probably thinks, that whatever. He decides that my client's lying. I have no indication that she was to this day. I don't believe she was. She was telling the truth. I never caught her in a lie. And so he entered an order that myself and my client are not to oppose the entry of a final judgment of foreclosure over in state court. Because bankruptcy is in federal court, foreclosure is in state court. I knew we could win her foreclosure because of something having to do with the condition precedent demand notice, which you may be aware, if they're going to foreclose on you, they have to send you a letter like 30 days in advance, says you're behind these payments. Here's what you have to pay to reinstate. If you don't pay it by this deadline, then we can foreclose. That's some federal regulation. So any of these federally insured loans, Fannie Mae, Freddie Mac, they have to give people a demand notice. It's written into all these mortgages.
Right.
Well, I happen to know because I just won a case on a demand notice in front of this judge that had the same defect as the one in this case for this lady.
So it's a slam dunk to win this one.
Right. I've got a great chance of winning in state court if we can just get around this alleged agreed order to surrender her property in bankruptcy. So the bankruptcy judge says, no, not having it. Mr. Trent and Miss Scott, you are not to oppose the entry of an immediate final judgment of foreclosure in state court. So I talked it over with my client, and it occurred to me, maybe we could just dismiss the bankruptcy. Because the state judge, first of all, doesn't like the federal judge controlling what goes on in his courtroom. Mm-hmm. He had already expressed that. Secondly, I did some research, and I found a law review article entitled, The Chapter 13 Debtor's Absolute Right to Dismiss. Read the article. It's great. Supreme Court case law cited in there. Even a decision called Law versus Siegel of all things. And it said we have every right to dismiss the bankruptcy. Once we dismiss the bankruptcy judge no longer has jurisdiction over this property. It's now back with the state court. His order no longer has effect. He doesn't have jurisdiction anymore. And then my client can defend herself. All she wanted was the right to defend herself on the merits. So this is the situation that gave Adria Quintela and the Florida bar the alleged, the basis to come after me and basically take my license. So this is the ruse. So what happened was we did the research, talked it over with my client. She had paid like $20,000 in payments for her other debts in the bankruptcy plan. But by dismissing the case, she was going to lose the benefit, and those other creditors would now be able to come after her again, and she's not going to get the discharge of all of her debts that she was hoping to get. But she decided it was worthwhile. She would rather save her primary residence. That's been her goal the whole time. She already surrendered like her renter house, her investment property and stuff. So we did a notice of voluntary dismissal of the bankruptcy case. Well, the federal judge, Judge Ray, set it for hearing. And I had a case from the Southern District of Florida that said there is no hearing authorized or permitted on a notice of voluntary dismissal. It's just a notice. There's no motion. There's no request. There's no hearing. But he set a hearing anyway for like 20 days out. Meanwhile, the bank's very astute attorney gets a quick hearing in foreclosure court and tells the judge, "Hi, Judge, we're just here to get our final judgment of foreclosure since Mr. Trent and Miss Scott are prohibited from contesting it." And I said to the state court judge, I have the transcript, I explained everything just like basically I explained to you, and said, now we're just waiting. I know that he's going to have to honor the dismissal, but right now we're in limbo because the order's still in effect until the bankruptcy judge officially dismisses the case. And she's dragging us in here, and I'm not allowed to oppose. So I just explained the situation to the state court judge. And I said, if you want to have the judgment entered, as long as it has a provision that says when the bankruptcy is dismissed, the foreclosure judgment is vacated, or just hold it in abeyance until we have this hearing in 10 days. Because if I didn't stand up for my client at that hearing, she could lose her discharge, because I know the bankruptcy case is going to be dismissed. He has to dismiss it. He has to honor that U.S. Supreme Court case law. And number two, so she's going to lose her discharge of all of her debts, and she's going to not be able to defend her. I couldn't let that happen. That's double jeopardy, right? That's going to destroy my client.
Right.
Maybe, I don't know if that's clear, but
yeah, it's clear.
Yeah. So I had to say, I couldn't just roll over and die and say, okay, get a state court judgment while, it was a conundrum. So I explained to the judge, I'm in a delicate position here. I would never disobey a court order, but this is all transcript. So the state judge says, well, there's nothing I can do until, Miss Scott, it's not even really up to me to consent to judgment. That would be on her. You know what I'm saying? Like, it's sort of unreasonable for me to even be, it's not she gets to decide what she does with her property, not me.
Right.
So the state court judge said, well, I'm not granting the bank a judgment because the bank wouldn't agree to have a provision in there that says this is vacated when the bankruptcy is dismissed. Of course, they don't want to do that. So the bankruptcy judge ultimately has the hearing and decides that, he's going to dismiss the case, get this, as a sanction against my client and I for violating the court order. He's dismissing it as a sanction. No, we already dismissed it as the reality, and he couldn't. So he makes up this fiction. He's dismissing it as a punishment to Miss Scott for abusing the bankruptcy process. And the bankruptcy judge orders me to send that order to the Florida bar. Now, mind you, me and this judge never had a cross word. We had 15 hours of hearings over 4 months, and he sustained most of my objections. He laughed at my jokes. I mean, we never had a problem. He never said, Trent, you're barking up the wrong tree. You know what I mean? Like, you're pissing me off. Nothing. Because all those hearings were about whether or not my client had actually agreed to the agreed order surrendering her property in the bankruptcy. So I was shocked that the judge ordered me to turn myself into the bar. But of course I did. And I include my transcript from the state court where I was totally open about everything. It's nothing unethical in anything that I've done. She had the absolute right to dismiss her bankruptcy case, and I didn't violate the court order. All it said was, shall not oppose the entry of a judgment. Well, I didn't oppose. I just explained might be prudent for the court to wait until we see what's going to happen, because I can't let my client get double whammy, get double screwed, double fucked. I'm sure we can say that on your channel.
Yeah. So what? So it goes in front of the bar, and did they have a hearing?
My case?
Yeah,
your
case.
Yeah. So here's where the conspiracy really kicks in. So the bar ignores the exculpatory transcript that I included, and they immediately assign it to Fort Lauderdale. And anyway, the bar goes ahead. They initiate a formal complaint against me, and lo and behold, who is the attorney that signed at the bottom but my old friend Adria Quintella? So I thought, didn't I write her a nasty letter once upon a time? Something like that. So miraculously, organization is not really my strong suit, but amazingly enough, I found my letter, my 2011 letter in 2020 when this happened. And there's my letter saying several people appear not to be doing their jobs. And how does he still have a license? And so I'm thinking, why are they running with this? Because here's the real defense to the ethics charge about this alleged violation of a court order. Every time an attorney violates a court order, it's not an ethics violation. The rule says it's an ethics violation to violate a court order unless it's an open refusal based on a belief that no valid obligation exists. So if somehow you could say I violated a court order, clearly it was an open refusal. It wasn't surreptitious. It wasn't sneaky. It wasn't underhanded. It was, Judge, we're entitled to dismiss this case. Everything was an open book. So it definitely fell within that caveat or carve out of the rule, undoubtedly. I mean, clearly. So Adria Quintella is prosecuting this case, and I decide, and it gets assigned to a referee. A referee is like a judge who's going to hear the ethics case. And the first rule of bar discipline in Florida is that the venue, that is the location where the ethics case is going to be tried, is supposed to be in the attorney's home district, which is defined as where their primary office is located, where their home is located, or where the offense was committed. In my case, it's Broward, and Broward. But somehow, the referee assigned is someone I've never heard of, Scott Suskauer out of Palm Beach County. So I take a look, and Scott Suskauer is married to Michelle Suskauer, who at that time was the president of the Florida Bar. They serve 1-year terms. It's mainly a ceremonial position, but before that, she worked at the Florida Bar in the same office as Adria Quintella for like 10 years. Okay,
so they're probably friends.
Oh, yeah.
Yeah.
So suddenly now, Adria Quintella could be her best friend's husband is the referee in my case, and he's in Palm Beach County. I mean, I practiced mostly in Broward. I had a good reputation. I knew the chief judge. I had like 4 trials with the chief judge, and he ruled for me every time. We got along. He laughed at my jokes. He said hi to me in the hall. And he's the one that would have, I was a good attorney. I wasn't a scumbag. Most judges I had a good relationship with at Broward. And even if I didn't know them, you know how it goes through the grapevine. They would know just from seeing me around and, being friendly. And because I was a friendly guy, I didn't personalize anything with my opponents, I was well accepted, liked at the courthouse as far as I could tell. I always got a warm welcome. Certainly in Judge Stone's courtroom, which was the foreclosure judge in state court that I dealt with the most. He ended up writing letters for me even about that case. They're not allowed really to get heavily involved, but he wrote a letter saying, in this case with Miss Scott, I've reviewed the file and Mr. Trent was open and obvious with the court, and I don't see what the problem is. I mean, even the judge wrote that on my behalf. No effect. So the case is up here with Scott Suskauer in Palm Beach County. Sorry about, covering my face, but it's just this guy, he turns out, I'm going to get sued for defamation. So let me just give you the disclaimer. This is my opinion based on the facts that I'm articulating in this broadcast, because those are defenses to defamation or slander. To all appearances, this man is an opioid addict, okay? I don't know if you've ever been around him, but they used to have him hang out close to the fetish factory when there was the big thing with all the pill mills and people were coming from other states to get drugs here, get opioids. And it's that certain really slow, like monotone way of talking, that constant concern with, when is this going to be over? When can I leave?
Right.
You could tell it's just desperate to escape because he wants to get more. He's coming down, you could tell. I know you said you don't have much experience with drugs, but you've lived
personally,
but
I've known plenty.
Oh yeah. Once you know that opioid personality, you could pick it up like that. It's that, I drool, but it's more drooling. It's drooling. No, it's just, this guy, he's a lug nut up there. He graduated from Northwestern University School of Law. He has to be able to have been able to read at one time, but he can't remember what exhibit we're on. He's looking in the wrong notebook. The lawyers, we give him notebooks. He doesn't know. He can't remember anything. He gets mad at me because I said, also they get temperamental about things that don't really make sense. I've seen this before. Right. I've had clients who were like that. So in this hotly contested ethics trial, he's saying he got mad because I said that the attorney for the bank in the Scott case was a flamethrower. And he got so mad. He's like, Mr. Trent, what's your language about it? Well, he didn't talk that energetically, but basically it was in that monotone. That's out of line. You cannot speak about have some respect for opposing. That was respectful, actually. If it's one trial lawyer saying another trial lawyer is a flamethrower, Is that pejorative? Is that some kind of an insult? Do you guys throw hands over that in the pen about like saying someone's a flamethrower? What?
If you sleep hot at night, you know how disruptive that can be. Whether you're having trouble falling asleep, you're waking up sweating in the middle of the night, or all of the above. That's where GhostBed can help. As the makers of the coolest beds in the world, GhostBed is your go-to for cooling mattresses, cooling pillows, and cooling bedding. From their signature Ghost Ice fabric to patented technology that adjusts to your body's temperature, every Ghost Bed mattress is designed with cooling in mind. So whether you want a plusher mattress that cushions your shoulders and hips, or a firm option with exceptional support, your Ghost Bed will keep you cool and comfortable all night long. When you purchase a Ghost Bed mattress, your comfort is guaranteed. You can try out your mattress for 101 nights, risk-free, to make sure it's the right fit for you. Plus, they offer free shipping, and most items are shipped within 24 hours. If you're not sure which Ghost Bed is right for you, check out their mattress quiz. You'll answer a few questions and get a personalized recommendation. Even better, our listeners will get 10% off for a limited time. Just visit ghostbed.com/Cox and use code Cox at the checkout. That's ghostbed.com/Cox and use code Cox for 10% off site-wide.
I mean, that says they're formidable.
Yeah,
So,
I was going to say, I understand.
It might be ambiguous to some people, but it's not. I don't see the negative, like the insult,
right?
With that, it was a compliment. In fact, she was a great attorney, very effective. She had that old judge thinking that my client and I were some real operators, apparently. So, so when I was getting ready for my ethics trial, I thought, this actually I didn't realize Suskauer's connection at the beginning, and I didn't realize. Maybe I wasn't aware. I don't know. I guess I didn't really challenge the idea at first of it being up in Palm Beach County with Suskauer because I thought I was so innocent that any judge would see, still naive.
Yeah.
So I there came a deadline by which I had to disclose all of my intended exhibits for the ethics trial. Exhibit number 1 was my letter from 9 years earlier to Adria Quintella and my article in Palm Beach Post because I wanted to be able to show the referee some sort of ostensible motivation for the bar coming after me.
Right.
Because, it's all gray area, sort of like subjective, like whether somebody has violated these things like conduct prejudicial to the administration of justice. I mean, that's in the eye of the beholder, So I was concerned that the referee would want me to be able to articulate some possible motive that the bar could have for coming after me on something when I didn't commit an ethical violation on the face of it. You know what I mean?
Right.
Like she had every right to do it. All I did was a voluntary dismissal of a bankruptcy case, which is 100,000% authorized. By the way, my client ended up keeping her house for like 6 more years until they finally took my license and had the suspension not be lifted after my period had run. And at that point, finally, she lost her house, but she was able to flip it and get like $350,000 because in that amount of time, like 6.5 years, it had gone up. She had like 100,000 in equity. She'd gone up to 350,000 in equity. So her house went from 4 to 7 or something like that in that time period. So basically, I won that case for her. They couldn't foreclose. The demand letter was defective, but they needed to get a workaround. They needed to get it through the bankruptcy court, and when that didn't work out, so I sent in my my exhibits to the bar because when you file something nowadays in court, it's email disseminated to all counsel of record.
Yeah,
and Adria Quintella was the counsel for the bar in the case. So when I sent my exhibits out, and Exhibit 1 was this letter. Up to that point, she didn't know that I would remember, that I would have that. That's what I believe. So the next time. Well, first of all, the bar immediately filed a strenuous objection to that exhibit and only that exhibit out of 24. Okay. And then the next time I filed something in the case, I got a bounce back that said, Adria Quintella is no longer employed by the Florida bar. And I was like, what? Wow. I mean, she had been working there 18 years at this point, worked her way all the way up from, assistant counsel in the local office to head of bar discipline for the state. I mean, she was basically a powerful politician at that point. And they're gonna just, she doesn't work at the bar anymore? Like, what the heck? How do you even fire someone like that? I didn't really know. So they have a cover story like, oh, it's a lateral transfer. It's been planned, for a while. Now she's a law professor at Florida State. But that's a pretty significant coincidence. It's pretty hard to I thought the bar at that point was probably going to drop this frivolous case against me, but they went ahead and continued with it, I think, just to save face. You know what I mean? They're not gonna, if they throw her under the bus, then how many prior convictions and disbarments and suspensions has she been involved in?
Proceeded
right,
over.
They can open that.
But the referee is still her husband, right?
Well, it's her friend's husband.
Her friend's husband, right?
Very closely connected.
Yeah, so that does, just because you change jobs doesn't change the relationship.
Well, yeah, and also the fix is still on.
Yeah.
Because there's other people involved, clearly, because I come to find out, I delved into this at some point, the way that the referee is assigned is like this. The bar files a case with the Supreme Court. The Supreme Court, the bar files a statement of what's the proper jurisdiction, which in this case, Adria Quintella, smart lady, filed Broward. But the next thing you know, there's an order from Chief Justice Charles Kennedy assigning the case to Palm Beach County, where the Palm Beach County Chief Judge gets to pick one of her minion to be my referee. Well, the Palm Beach County Chief Judge is Krista Marks, or was Krista Marks. Krista Marks, I had previously filed a JQC complaint against because she was hiding the transcripts from Epstein. See, because Epstein had this cushy deal with the state attorney up in Palm Beach County where he was busted for sex trafficking, but they put him on house arrest, but then he had like an escort from the sheriff's office, and the sheriff ends up being Krista Marks' husband. And then years later, Epstein becomes a big public enemy and the scandals break, and now he's been probably murdered in jail. And so the Miami Herald was trying to unseal the grand jury transcripts from like 7 years earlier to figure out if the state attorney had soft pedaled the presentation to the grand jury about Epstein because he had so much money and influence, and all the people that were involved in that and risked being exposed were former Sheriff Rick Bradshaw, some guy Ehrenberg, I don't know, is another one that's associated. Like her son worked at the sheriff's office. There was a whole bunch of like inbreeding going on. You know what I mean? There was a whole bunch of close relationships there. There were many close relationships. So now it's Krista Marks, who I'm sure isn't a big fan of mine. I'm sure she probably remembers this JQC complaint. I just filed it as a random citizen because I read an article. I didn't have a particular axe to grind against Epstein. In fact, I kind of think it's unfair that sometimes he's grouped in with like serial killers, and that's, you know what I mean? I don't equate his conduct with serial killers in terms of, evil.
I'm sure that's going to go over well in the comments. Go ahead.
Well, whatever. You can eliminate it if you want. Okay. You really think if you really think he's a serial killer, I mean,
I don't think he's a serial killer.
I don't think it's an equivalent. I don't think it's a comparable crime. I mean, I'm not saying I like Epstein. I'm not saying I don't think Epstein should have been in jail. I definitely do think he should be in jail, should have been in jail, but whatever. I have a defense lawyer at heart. I always say the best.
I was going to say, yeah. Okay.
But on this case, I was on the side of those people that are going to be attacking me on your channel because I wanted the grand jury transcripts to come out.
Right.
And I read this article like in 2016. It didn't have anything to do with me, but it blew my mind because the Miami Herald is petitioning the Palm Beach County Court to release the grand jury transcripts so they can find out what went on with Epstein. And Krista Marks' husband is the sheriff or something, or the state attorney who stands to be exposed if the transcripts reveal a soft pedal job, which we think they're going, which the indications are since he got such a slap on the wrist for sex first time. And instead of recusing herself, Krista Marks denies the Miami Herald's motion. I mean, maybe it's just me, but I think when you have personal involvement like that, you have to disqualify yourself and let some other judge rule upon it. So to me, it was a blatant ethics violation. And like I said, I really believed in like ethics. And I thought that was disgusting that she would, I'm for, government transparency. So she wants to hide that shit. I wasn't down with that. So anyway,
now she's in charge of, she's now the new referee.
She gets to pick the referee.
Oh, okay.
Because for some reason, Chief Justice of the Florida Supreme Court, Charles Kennedy, sent my case to Palm Beach County, even though the file says Broward for me. And then it just happens to be Susgour, Krista Marks, I don't know. So Susgour he's vegetable up there. You know, he doesn't know what's going on. The Florida bar is trying to get 2-year suspension. But Suskauer is not, I don't think he's an evil man. He's just probably under the thumb of, you know, certain influential females and certain, you know, addictions, quite frankly. That's my opinion. My opinion, solely my opinion, based on my experience. But he didn't really first of all, he wanted it to be over immediately. He didn't really want to hear like 3 days, like was scheduled. You know, what time are we getting out of here? Are you guys ready for a break? I need to take a break. You know what I mean? That's all it was. That's all he would ask. The only questions practically he asked the whole time were, how much longer is this going to take? When are we going to get out of here? You know, and it's not my life on the line, but pretty close to it. It's pretty serious. And my clients too. You know, I had clients there trying to support me and testify and file affidavits. I had opposing attorneys that filed affidavits for me. I had judges that tried to help me, you know, but anyway, so Suskauer ends up saying that I deserve a 6-month suspension, which is less, you know, like I said, he wasn't consciously like sold out. I don't think it's more subtle than that. You know what I mean? Like they have whatever. He doesn't realize, in my opinion, he wasn't openly a member of the conspiracy. He was more like a pawn for them. Right. So he recommends 6 months and I'm like, hell no, I didn't do anything wrong. I and the Florida bar both challenged that ruling, and the Florida Supreme Court, without any explanation at all, changes it to 2 years.
Okay.
No explanation. I'm not kidding. All it says is this case is before the court on the petition to review the referee's determination. We agree with the referee's determination as to the facts, but we disagree with his punishment. He's now 2 years. What? Why? I mean, I didn't commit an ethical violation. 2 years, you have to reapply. Well, not reapply to the bar, but you have to file a whole new lawsuit, like a petition, and then pay money and go through all this process to see whether or not your suspension should be lifted. They suspended me for 2 years, and it's like, under the circumstance, I mean, it's just incredible. So it's pretty obvious to me, based upon my letter, the article, you know, Krista Marks, Adria Quintella, the fact that she's no longer employed by the Florida bar. You know, I think there's a pretty compelling case to be made that, you know, this was clearly, I mean, there's no explanation for how it got sent to Palm Beach County. I mean, none. So ultimately, when they took my license, refused to reinstate me, I decided, well, I'm going to just, to demonstrate how unfair the bar is, truly, as an institution, I decided I was going to file bar complaints against people that committed ethical violations in prosecuting me, my alleged ethical violation. Just for example.
That's probably not a good idea.
Well, it's the idea that I chose because now, I mean, the idea was really just to, I already knew that these people were so dead set against me that I was never going to get reinstated. Like I should have gotten reinstated the first time. I mean, I did everything.
Well, this is 2 years. I mean, this is a suspension for 2 years. Yeah. Like you get reinstated after the 2 years.
After 2 years, you petitioned for reinstatement and it was denied.
Okay.
So that's when I started filing. That's when I started filing bar complaints against bar people.
Okay.
Still haven't actually filed it against Adria Quintella because, you know, I don't exactly have conclusive, overwhelming evidence. I have quite a few strong inferences, a strong circumstantial case. Right. But, you know, I did write her one email. You know, I don't stalk this lady. It's nothing like that. But I did write her an email. I filed bar complaints against Charles Kennedy and Judge Suskauer and a few others. And this prosecutor that was assigned to the bar prosecution who hid the transcript. I call it the exculpatory transcript of the hearing in state court where I explained to the judge, I'm not here to oppose. I'm not allowed to oppose. Here's the deal. We filed a notice of voluntary dismissal. We're waiting for the hearing, whatever. That transcript, it was deep, what is it, 86, deep six? It was hidden the whole time. It was hidden from the grievance committee that voted to move ahead with this complaint. And, you know, it clearly was concealed. He even pretty much admitted it was concealed in an email because I knew the grievance committee was meeting. This was before it went to Suskauer and all that. I knew the grievance committee was meeting. I'm not allowed to go. It's just the bar prosecutor. It's like a grand jury. But I was able to ask the bar prosecutor, you know, have you given my exculpatory transcript to the committee before the hearing? Oh, yes, that's being provided to the committee members today. Like, today? the rule is they're supposed to have all the materials like 2 weeks before they meet.
Right.
So they can review it. It's just people. And I said today, and he actually wrote me back an email that said, you misunderstood the meaning of the word today or something like that. Like, what? It defies credibility when you really get into the details of like the correspondence and everything. It's just pretty overwhelming that, there was a lot of shady stuff going on. So where was I? So I file these bar complaints. Nothing really happens. File it, they just rubber stamp whatever the bar did. And it's really unfortunate. But so my class action gets dismissed. They decide to retaliate against me after I, exposed a real threat to the reputation of attorneys. I mean, and it's not just me. The other attorneys that really stood out defending homeowners in foreclosure, that really were aggressively pursuing and exposing the fraud of Wall Street and the use of fake fabricated evidence on a wholesale basis to foreclose on people. The real fighters, boom, boom, boom. The bar has just come after us and taken us out one by one. Mark Stopa, he probably great attorney, probably won more appeals for homeowners than any of the rest of us, than the rest of us combined over here in the second DCA in Lakeland. They not only did they disbar him, they raided his office with FDLE, Florida Department of Law Enforcement. That's how bad they were after him. And you know what he did? I mean, they have a lot of charges on his bar thing, which I don't know how many of them are true. But I know he did a tremendous amount of work for his clients. He was a great advocate. He won a lot of cases. He won appeals that gave other homeowners something to utilize to win their cases. But I don't know. He just had a bit of a temper, I guess, because he would tell judges to their face that they were incompetent or corrupt. And that's frowned upon.
Yeah.
Me, I was still like the Southern guy. I was still polite. I never really mouthed off or showed my ass. I would maybe roll my eyes or shake my head or something. But, I was always maintained civility, yeah. And because I was, he must have come from a slightly wealthier family. He had a little bit more cushion. Me, I always knew my law license was my only ticket. So like, I wasn't going to be out there, throwing around a bunch of motherfuck this and, you're an asshole. So, and that's something similar happened with Bruce Jacobs, who's a Miami attorney who is very aggressive, very effective for homeowners. And Bruce would write in his pleadings to the judges that it's either corruption or incompetent. Either you guys are unqualified to be judges or you're entirely corrupt. And last I checked, we had freedom of speech. That's not one of the oaths you take when you become an attorney, is to relinquish your right to speak the truth as you perceive it. I mean, and they did a petition for emergency suspension on the guy. For what? For typing some pejorative term in a brief. I mean, clearly he hit a nerve, just like I clearly hit a nerve when I said several people appear not to be doing their jobs, or what is going on here, in my letter to Adria Quintella in 2011, for her to hold a grudge for 9 years over something like that.
So you're saying that
same
they're
thing with the bar, like
systematically going out and taking out all of these attorneys that...
I mean, I didn't use the word systematically, but I mean, the three most aggressive.
Yeah.
And who were, had made a name for ourselves, they came after all of us.
Okay, who was the other one?
Mark Stopa, Bruce Jacobs, and myself.
Okay.
I mean, I guess I should be honored I didn't get a petition for emergency suspension or emergency disbarment, So it's really unfortunate. Like a disbarred or suspended attorney is not a very empathetic victim. You know what I mean? Like, nobody gives a shit.
So how long?
You must be a scumbag. I used to think the same thing. But ironically, they use the bar as a political tool to take out anybody who rocks the boat, who actually fights against the establishment. And that's something that needs to change.
So how do you get your license back?
I don't think I'm ever going to get my license back, certainly not from the state of Florida, unless, you would think that you would get like a changeover in personnel at some point, you know what I mean? But for them to give me my license back, they want to, the grounds that they used before, they used the ground that for denying reinstatement that I owed the IRS money. Well, what do you expect when you take somebody's professional license? You know what I mean? And besides, I had a payment plan set up with the IRS, and there was case law that says an attorney is entitled to be reinstated when he has a tax delinquency as long as he has a payment plan in place. So I had everything that I needed to have,
right,
and they're still going to deny it. So, I'm 52 years old. I don't know how much longer I'm going to be blessed to be alive. And I don't want to go down in history. I don't want my child. I don't want my kids. I don't want people that might buy my book or see my book in the future to be like, oh, this guy's just a scumbag. The truth needs to come out. The truth needs to come out about the banks and how the kind of fraud, the criminality that they're engaged in. The truth needs to come out about anything that involves corruption in government. And the Florida Bar is like this secretive organization. There's no oversight practically. It's all very mysterious, hush hush, behind closed doors, and it has so much potential for abuse. And so many people who've had very legitimate bar complaints. I mean, I heard this every day of my career. Can you believe this attorney did this, this, and this to me, and the Florida Bar didn't do anything? So I think they're largely ineffective as a disciplinary arm of the court system. And I think there's a lot of potential for it to be used as a method of political retaliation or, just keeping down those people that might rock the establishment. It keeps corruption entrenched when they have this weapon that they can use, the Florida Bar. They don't have to really observe due process. They just do whatever they want. They don't even have to respond to your statutory defenses. I mean, I had a statutory defense based on the language of the rule that says it's not a violation, it's not an ethical violation to violate a court order as long as it's an open and obvious refusal based on a belief that no valid obligation exists. That's exactly what this was. Never in the entire disciplinary process did the bar attorney, any of the judges, did anybody say, no, that doesn't apply because X, Y, Z, or it wasn't an open and obvious. Nobody ever addressed that argument. It's a joke. They just leave it alone. And I've seen this too as an appellate attorney. You could have the greatest case in the world, but if it's going to shake up the powers that be or the establishment, you get what's called per curiam affirmed. That's like, we don't even need to explain. We're just going to affirm what the lower court did. So, your 80 pages of brilliant legal argument and issues and proof that the other side is committing all this fraud, PCA, we don't even have to explain it to you. And I've seen that utilized to perpetrate grave injustices on people. So, my book, The Banker's Secret, that's BANKERS' secret, is a story basically of my career, what I learned about the banks. It gives all the documentation, all the details, all the transcripts of the big court hearings, and all the evidence that you would need to really understand more about this whole securitization fraud, robo-signing, and what it means like for the future, for the property markets, for Wall Street, and what we can all do about it to have less corruption. I think most of your audience certainly can agree with me that that's a worthy goal to have.
Hey, you guys, I appreciate you watching. Do me a favor, hit the subscribe button, hit the bell so you get notified of videos just like this. Please go into the description box and click on the link. We're going to have Kenneth's book that he just talked about. Does it go over this? Does it go over this case?
Not my bar case, but it goes into great detail about the federal class action and all that with the robo-signing and
awesome.
etc.
All right, cool. It goes over everything that we just went over in great detail. Has everything you need to know about the case. Go into the description box, click on the link. It's going to take you to Amazon. So you can buy a copy of the book, download it, whatever. All right. I once again appreciate you guys. Thank you very much for watching. See ya.